Friends, my name is Nizamuddin Ahmed Siddiqui and I am Assistant Professor of Law at West Bengal National University of Juridical Sciences, Kolkata. The present module entitled Humanitarian Intervention. The learning outcomes of the present module include: number 1, to give students an overview of humanitarian intervention, its temporal scope and application to armed conflicts, as well as measures to limit its applicability. Number 2, to acquaint students with an understanding of the nature, scope and meaning of humanitarian intervention and its limited protection under international humanitarian law. Friends, let us begin with an introduction to humanitarian intervention. Most of the current conflicts show the response to a situation that involves a legitimized use of armed force that is often labeled as humanitarian in nature. The expression evolves from such legitimized use of armed forces as a humanitarian intervention. Albeit terms such as military humanitarianism, humanitarian war and humanitarian bombardment. Such terms are paradoxical and revealing. The pretext of most international conflicts by dominant powers have been legitimized by the use of humanitarian considerations, and such mandates that were originally intended to prevent actual human rights violation has become risky due to unwarranted use by the dominant powers to fulfill their own strategic needs of the country, leading to distortions on the legislative intent and purpose of international human rights law. This allows international humanitarian law to masquerade as a justifiable unilateral armed intervention. They also provide impunity from full compliance with the spirit and letter of international humanitarian law on the premise that such intervention is for the purpose to solve a humanitarian crisis, which forms a secondary priority for such nations. Thirdly, the very notion of forcing humanitarian law by way of armed force defeats the spirit of international humanitarian law and provides a leeway for powerful states to fulfill their political and military agendas. Such hindrances are in contradiction with the envisioned fundamental principles and the very nature of humanitarian law and action. Friends, to further prevent the abuse and vagueness of international humanitarian law that provides an unwarranted leeway, international humanitarian law has to redefine itself in terms of how it cannot serve itself as a basis of armed intervention in response to grave violations of its provisions, the use of force being determined by the United Nations Charter. This also prevents organizations such as International Committee of Red Cross, also known as ICRC, and other UN appointed organizations to pronounce on the legitimacy or legality of such intervention. Let us now try to define what is the problem. The UN operations in Somalia and Iraq and NATO's intervention in Kosovo has been labeled as humanitarian intervention. The principle to intervene via humanitarian grounds has been contentious, both in law and international relations. The emerging legal principle of responsibility to protect, also known as R2P, and the common concern, referring to Common Article 1 of the Geneva Conventions, are an original impulse of recognizing the international system as having peremptory normative values, that is, the ability to be enforced as binding. Both of them are premised on the belief that mutual interests of all people, meaning thereby states, would lead to a state of well-being without regards to boundaries or legal jurisdictions. In such approaches, the greater idea and concern is to overcome traditional approaches to state sovereignty, both in their labeling of problems and their respective responses. Friends, let us now proceed further. And let us now discuss the policy challenges that are involved in this debate. Military interventions taken by non-concerned parties for human rights protection purposes have been controversial, especially when it has happened. For instance, in Somalia, Bosnia and Kosovo, and where it has failed to happen, as in Rwanda. For most Western humanitarian thinkers, this kind of activism has been an internationalization of the human conscience. For others, it has been nothing short of an alarming breach of an international state order, which is dependent on the sovereignty of states and the inviolability of their territory. While some argue that coercive interventions are effective and successful, the larger questions of violating legality, processes and misuse of precedent pose a question of whether in whose perspective it is right or wrong. The UN Charter, Article 2, Clause 4 states that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. NATO's intervention has been most notoriously brought this controversy in its most intense head. The legal justification for military action without new Security Council was not even argued, and the ignorance of that has led to much more carnage and destruction than aversion, and NATO was criticized for its dismay of procedures of its operation and conduct. The justification is given by the then Secretary General Kofi Annan, who made a stark dilemma to the world, stating, if humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to a Rwanda, to a Srebrenica, to gross and systematic violations of human rights that affect every precept of our common humanity? Let us now focus on the military interventions and the inviolability of peremptory norms, understood as jus cogens norms under international law. In a word, given the customary as well as erga omnes character of most norms of international humanitarian law, all states are deemed to have a right to ensure that any other states respect customary international law, and all states parties have the obligation to do so vis-a-vis any other state party to the 1949 Geneva Conventions and Additional Protocol 1. Hence, such intervention would best derive its legal grounding from Common Article 1, which has a quasi-constitutional meaning under the current legal system. The idea behind such an article is that while there are a plethora of rules that define international humanitarian law, the key problem of ensuring such rules be respected contributes to state compliance, which Common Article 1 reinforces. This endows the Geneva Convention to hold a special character in the field of international humanitarian law and is stalwart of upholding the rights and duties of states and interstate behavior. At the same time, the Secretary General had expressed fear, stating the legal status of humanitarian intervention and the challenges that it poses to the future of global order. A key obstacle to legalizing unilateral humanitarian intervention is the overriding concern that states would mostly use a pretext of intervention to wage wars for ulterior motives. While the Secretary General's report on R2P represents an important attempt to build consensus on the thorniest issue of our time, keeping tabs on states' implementation to ensure the states' obligations seriously ability and authority of the Security Council to mandate specific actions to developing acute humanitarian crisis and ensuring states' compliance with its instructions. Being very few recommendations are too utopian and unfeasible for the UN to enforce. While R2P comes with a variety of checks and balances to ensure states act with a genuine responsibility, history has suggested otherwise. The violations and disregards of UN security in NATO's intervention, America's intervention in Iraq and the Rwandan genocide are few devastating examples as to how these rules are hardly even discussed, and the states and organizations justify those who are against this principle. From the viewpoint of ICRC, when it comes to humanitarian law, it is a contradiction in terms to speak of intervention or interference, as the term humanitarian should be reserved to alleviate the suffering of the victims. Yet the intervention is military in nature and is often carried out with a visceral motive. International humanitarian law recognizes the right to provide humanitarian assistance, and impartial humanitarian aid is something that does not come in the purview of infringement or interference of a state's national sovereignty. Friends, this makes humanitarian law a very controversial issue. In a 1986 ruling in the International Court of Justice, it was held that the provision of humanitarian assistance is to escape condemnation as an intervention in the internal affairs of another state. It must be limited to the purposes hallowed in the practice of the Red Cross. This was observed in the case concerning military and paramilitary activities in and against Nicaragua, also known as Nicaragua versus US. The court concluded in para 268 that the use of force could not be the appropriate method to monitor or ensure such respect. Humanitarian law stipulates when grave breaches of provisions are committed, those responsible to be prosecuted and punished as criminals. However, humanitarian intervention is a jus ad bellum question. The question as to when the right of a state or a group of states resort to force only has to be read explicitly with the UN Charter. In principle, intervention is only legitimate if it is part of the exceptions of Chapter 7 of the UN Charter by virtue of Security Council's direction to tackle international threat to peace and security, or when exercised the right to individual or collective self-defense, as is provided under Article 51 of the UN Charter. The right to self-determination is yet another instance where such discretion may be exercised. However, the right to take unilateral action or force against a state that commits human rights violations or breaches of humanitarian law are not a part of such exceptions. Neither is it part of international norms or customs. Let us now discuss about Common Article 1 of the Geneva Conventions. Common Article 1 of the Geneva Conventions, on the other hand, explains that with the certainty that there exists an individual and collective obligation to respect and ensure respect of international humanitarian law. Violations of the common article, that is, violations of international humanitarian law, give states the power to take jointly or separately, in cooperation with the United Nations as well as the UN Charter, including Protocol 1 additional to the convention. Common Article 1 paves way for what is to be addressed when such events happen, and the charters and conventions further specify that cause by addressing what is to be done when such breaches take place. The Security Council, by deriving legitimacy from Common Article 1, can do a variety of things at its disposal, from sending of troops to condemnation with partial to full interruption of economic relations as an intermediate measure. If by following this protocol an armed intervention may be deemed necessary, then the Security Council can decide the UN forces or delegate it to a state or another regional security body. There exists no reason for a principle of responsibility to protect, because elements of responsibility to protect are already covered by the further expansion of Common Article 1, in tandem with the UN Charter, Geneva Conventions and other UN documents. The ICRC further reiterated its position on this by stating that they do not want the states to have a view that interventions are inevitable, but rather as a result of certain extreme conditions that contain gross human rights violations. The ICRC further stated how this attitude would lead to a systematic use of armed intervention for humanitarian purposes that completely abdicate international community of their true responsibilities. And what are these true responsibilities? Preventing conflict and promoting the basic values expressed in international humanitarian law. The obvious outcome of an intervention, even in the name of humanitarianism, leads to further taking of prisoners. ICRC finally concluded, stating that parties to the conflict and those who suffer consequences must discern a clear distinction between humanitarian and military entities, and blurring of such distinction must be avoided. Let us now discuss the scope and content of Common Article 1 as an alternative. As already discussed, all states have to respect as well as ensure respect for humanitarian law. This is a two-sided obligation. As to respect means that the state is under an obligation to do everything it can to ensure that the rules in question are respected by its organs as well as others under their territory. The phrase "to ensure respect" means that states, whether involved in conflict or not, must take possible steps to ensure that the same rules are respected by all, particularly the parties to conflict. Originally, the drafters did not intend to envisage the provision derive other provisions in the convention to be followed. However, the language of the article allows the parties to enforce universal compliance with humanitarian principles underlying the conventions. The phrase "in all circumstances" under Article 1 further creates an unconditional obligation upon the parties to comply with the rules, especially not subject to constraint to reciprocity. The law, being peremptory and binding in nature, is further asserted by the ICJ in an opinion on the legality of the threat or use of nuclear weapons, noting that a great many rules of humanitarian law is applicable that are so fundamental that these fundamental rules are to be observed by all the states, whether or not they have ratified the conventions that contain them. The issue of enforcement and compliance of such international humanitarian law has thus become a central feature in states and organizations. And having established what the scope and content of this article entails, it must be followed on how this provision has achieved several dimensions and legal development. Friends, let us now examine the interpretation of the phrase "in all circumstances." The phrase "in all circumstances" was crucial in Article 25(1) of the Wounded and Sick Convention and Article 82 Clause 1 in the Prisoners of War Convention. These provisions were construed to effectuate that the conventions were to be respected in peace as well as in war. Contracting states cannot by virtue of this phrase even prohibit any valid pretext, legal or other, for not complying with their conventions, hence making the obligation to respect international humanitarian law rules in an unconditional manner. Another interpretation of this phrase would mean that even internal conflicts or non-international armed conflicts would apply under this article. It was evidently assumed that had the phrase not been inserted, the convention's obligations would have applied only to international conflicts. The phrase also implies a prohibition of negative reciprocities and reprisals. In the ICRC's commentaries to the conventions and additional protocol 1, the term has been understood to mean the same as envisaged in article 60 clause 5 of the 1969 Vienna Convention. Let us now examine the various dimensions of the obligation to ensure respect. In furtherance of that intention, let us discuss some concrete examples. Common Article 1 clearly urges states to be under an unconditional obligation to do everything it can to implement the rules of war jus in bello, which pertains to conduct during war, as well as jus ad bellum, which includes justifications for causing the same. The Tadic case in the 1999 judgment of the ICTY established a blanket obligation upon states that violate not only when its armed forces breach such rules, but also when culprits, irrespective of their nationality, are acting under the command and control of the state, even if they are not from the armed forces. It is hence obvious that armies and military abide rules within and outside their national territories. The decision of the International Criminal Tribunal for Yugoslavia, or ICTY, in the case of Duško Tadić, as we have just mentioned, is a case in point that stressed in its ruling the importance of the state's armed forces to respect humanitarian law. The ICTY stressed that as a consequence of absolute character, these norms of international humanitarian law do not pose synalgematic obligations, that is, obligations of a state vis-a-vis another state. Rather, they lay down obligations towards the entire international community as a whole, with the consequence that each and every member of the international community has a legal interest in their observance and consequently a legal entitlement to demand respect for such obligations. The word ensure respect for international humanitarian law also convenes meetings of high contracting parties in application of Article 7 of Protocol 1, resorting to the protecting powers in ensuring enforcement in the system of ensuring minimal breaches, especially grave ones, or call upon an international fact-finding commission established under Article 90 of Additional Protocol 1. The additional protocols henceforth expanded the scope of Article 1 to not only provide prohibition of recourse to force, but also allowed the inclusion of jus in bello to be dealt by the UN by way of Article 89 of Protocol 1 to enforce international humanitarian law within the UN legal framework. Another example that shows the execution of common article is the example of Israel-Palestine conflict. The steady deterioration in the situation of the Israeli occupied Palestinian territory made the Security Council as well as General Assembly to add another dimension to the obligation to ensure respect for humanitarian law. Both organs called upon the UN Secretary General in cooperation with International Committee of the Red Cross ICRC to convene a meeting of the high contracting parties of the Geneva Convention. Referring to Common Article 1, they asked each party to contribute and listed down the explicit grounds for collective responsibility with respect to the occupied territories. The Common Article, however, has been curbed thanks to responsibility to protect or R2P principle. and other forms of statist or militarist intervention. Increasing reliance over the use of force in a basis of humanitarian consideration and to ensure respect for international humanitarian law has hence blurred the very distinction of jus ad bellum and jus in bello. This has led to a militarization in the implementation of international humanitarian law, something that defeats the very letter and spirit of humanitarian law. This imposes further questions of selective implementation of norms and humanitarian law, considering the politically induced nature of the Security Council's decision making process. This became very much evident in June 1999 when the Security Council gave its ex post facto political blessing to NATO air raids intended to put a violation of humanitarian law. The legality of such an action is still debated as something which is legally unjustifiable, however morally correct. This might have been a positive step, however illegal, though this has led to justification of force as a tool for intervention to ensure respect for humanitarian principles in a situation of humanitarian concern. Friends, let us now summarize our discussion. The UN Security Council has taken cognizance to condemn and pressurize certain states that have grossly violated humanitarian law on a large scale. A breach of peace under Article 39 of the Charter of the United Nations, despite certain anomaly that exists in the application of the same. Specific countermeasures were invoked using this article, which led to the resolution 688 that condemned repression of the Iraqi civilian population in many areas of Iraq, including Kurdish populated areas. The same was held in many other resolutions that have denounced the massive violations of humanitarian principles, such as Bosnia-Herzegovina, Kosovo and Somalia, to name a few. Overall, it can be said that international humanitarian law can be to a limited extent apply to humanitarian interventions, and there exists a need to update the legal and practical approaches towards handling new types of interventions. These types of interventions which do not fall within the slots that international humanitarian law has defined and also provide some barrier to qualify most armed interventions to actually be humanitarian in nature. With this, friends, we come to an end of this module. I thank you for your patient hearing.